Does the doctrine of eclipse apply to a post-constitutional law? In Deep Chand vs. State of UP, AIR 1959, the Supreme Court held that a post-constitutional law made under Article 13(2), which contravenes a fundamental right, is nullity from its inception and a stillborn law. It is void ab initio. The doctrine of eclipse does not apply to post-constitutional laws, and therefore, a subsequent constitutional amendment cannot revive it. The minority, however, expressed the view that the doctrine of eclipse is applicable even to post-constitution law. In Mahendra Lal Jain vs. State of UP, AIR 1963, the Supreme Court approved the majority view expressed in Deep Chand's case and held that the doctrine of eclipse applies only to pre-constitution law under Article 13(1) and not to post-constitution law under Article 13(2). There is a clear distinction between a pre-constitution law and a post-constitution law. The voidness of the pre-constitution law is not from its inception but only from the date of the commencement of the Constitution. On the other hand, the voidness of a post-constitutional law is from its very inception, and such a law cannot therefore exist for any purpose. But in State of Gujarat vs. Ambika Mills, AIR 1974, the Supreme Court modified its view as expressed in Deep Chand and Mahendra Lal Jain's cases and held that a post-constitution law which is inconsistent with fundamental rights is not nullity or non-existent in all cases and for all purposes. The doctrine of absolute nullity is not a universal rule, and there are many exceptions to it. A post-constitution law which takes away or abridges the right conferred by Article 19 will be operative as regards to non-citizens because fundamental rights are not available to non-citizens. Such a law will become void or non-existent only against citizens because fundamental rights are conferred on them. The voidness in Article 13(2) can only mean void as against persons whose fundamental rights are taken away or abridged by law. Non-citizens cannot take advantage of the voidness of the law. Accordingly, the court held that the Bombay Labour Welfare Fund Act, 1953 was valid in respect to non-citizens. The respondent, a company, had challenged the validity of the Act on the ground that its provisions violated the fundamental rights of citizens, employers and employees, and therefore, they were void under Article 13(2) of the Constitution. It was held that even assuming that under Article 19 a company was not a citizen, it was entitled to move the High Court and seek a remedy for infringement of its ordinary right to property. The provisions of the Bombay Labour Welfare Fund Act, 1953 were not non-existent, but were valid laws enacted by a competent legislature in respect of non-citizens, and the company could not take the plea that its right to property was being taken or abridged without the authority of law. In order to remove the difficulty created by the Supreme Court's decision in Golak Nath's case, the Constitution, 24th Amendment, Act, 1971 was enacted. By this amendment a new clause, 4, was added to Article 13 of the Constitution which makes it clear that constitutional amendments passed under Article 368 shall not be considered as law within the meaning of Article 13 and, therefore, cannot be challenged as infringing the provisions of Part 3 of the Constitution. The validity of the Constitution, 24th Amendment, Act, 1971 was considered by the Supreme Court in Keshwananda Bharati case. The court overruled the Golak Nath case and upheld the validity of the said amendment.